Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about a topic that is going on news for past few days, and there is a kind of conflict going on between judiciary and executive, and this issue is regarding the right to be forgotten, and we are going to discuss about that what is the stance of judiciary, what is the stance of executive, and what are the global examples about this regard that we can look into to understand this topic in more detail. So, let us start and delve deeper into the topic of right to be forgotten. So, first of all, we try to understand that what is the context with regard to which we are discussing this particular topic. So, actually last week the central government told the Delhi High Court that the right to be forgotten is part of the fundamental right to the privacy. And the reason why this issue came in news is because there are several petitions, and as of now there are 8 petitions that are filed in the courts of different states, in different high courts of India, we can say, where the people or petitioners are seeking the enforcement of the right, where they want their data, where they want their record, some particular kind of record, or they want some information regarding them to be quashed or to be erased from all the internet, all the social media, and different kind of, we can say, in different kind of media. So, however, this particular right of to be forgotten has not been enforced by the executive branch of the government, or is also, as far as the legislature is concerned, we do not have any statutory provisions to ensure this right to be forgotten. So, that is whole issue is all about. However, if you try to understand that what is the meaning, actual meaning of the right to be forgotten. So, actually this right allows any person to seek deletion of information from the internet or any other kind of social media. And if you try to understand that which kind of information can be erased as per this right to be forgotten. So, first of all, this information should be of private in nature, and also not in all circumstances all the information has to be erased. There has to be some special circumstances taking cognizance of which the Supreme Court or the High Court or any other judicial branch of the government can ask the government and can ask the internet provider agencies, can ask the search engines like Google, can ask the social media giants like Facebook and Instagram and all these kind of things, or all these kind of platforms to erase the information if it is of damaging in nature or the special circumstances are met. Now, let us try to understand that what has been the stand of judiciary in India as far as the right to be forgotten is concerned. So, first of all, the matter was referred to the Delhi High Court in year 2016, when a banker belonging from Delhi has a marital dispute and he wanted to erase all the relevant information regarding to marital dispute from the internet. So, that is when the Delhi High Court ordered this, because the marital dispute has already been settled. The both parties had agreed to whatever the verdict was given by the court, and that is why there was no need for this information to be published, or no need for this information to be open for everyone on the websites as well as on the internet. Later on in year 2017, another matter was referred to Karnataka High Court, where a woman approached the High Court and asked that there was an issue of marriage certificate, and the marriage certificate that was available on the internet, it was shown that this particular woman is married to a certain man. However, this woman had contested this fact and said that she has never married to this particular person, and the both party again has we can say reached to a final verdict, and we can say both party agreed to this particular statement, and taking cognizance of that, Karnataka High Court demanded that this particular information regarding her marriage certificate should be erased from the social media as well as the internet. Further, in the same year, in the month of February, another matter was referred to the Delhi High Court, where it was hearing a case involving a man who requested to have information regarding his mother and wife to be removed from a search engine, as it was private in nature, and he did not want this information to become public and to know for every person to know about that particular information. Similarly, in May 2019, there were certain news reports regarding Me Too allegations were placed against the managing director of a media house, and as he was acquitted and no such proof was found against him, the Supreme Court, Delhi High Court actually said that every person has the right to be left alone and right to be forgotten, and that is why, taking that into cognizance, the Delhi High Court asked the search engines to remove the relevant information from the internet, or relevant allegations from the internet. Further, in year November 2020, the Odisha High Court, the matter was referred to Odisha High Court, where a woman who was subjected to rape, and this particular video had been uploaded by the rapist, of this whole incident and taking very strong stance on this particular matter, the Supreme High Court, Orissa High Court has said that allowing such objectionable photos and videos to remain on a social media platform without the consent of a woman is a direct affront on a woman's modesty and, more important, her right to privacy. So, Orissa High Court has taken a stance that this particular video that is available in the public domain affronts, or we can say actually threatens the right to privacy of this particular woman, and that is why this is not a good stance. However, we have to keep in mind that Orissa High Court did not actually order the internet agencies to remove the video. Just this particular statement was, we can say, released by the High Court. Further, in year April 2021, another judgment referred to Delhi High Court, where Delhi High Court asked to remove certain search results from the search engine. However, the order was being opposed by the Google, which is the largest search engine as of now. Now, after understanding the stand of judiciary on this whole particular issue, we can try to understand that what has been the stand of Government of India on this particular issue. So, Government of India has clearly said that the right to privacy has been included as a fundamental right under K.S. Puttaswamy. That was a historic judgment released by the Supreme Court in year 2017, where the right to privacy has been included as a fundamental right under Article 21st. So, the Government of India has clearly said that right to privacy is recognized as a fundamental right, and the Government of India believe that the right to be forgotten is also being evolved and should be included in the right to privacy, on which the government is continuously carrying out the deliberations. To further prove its point, the government has said that government is trying to right now looking at, and the Joint Parliamentary Committee is there, that is currently discussing a bill that is called as Personal Data Protection Bill. That was Joint Parliamentary Committee was set up under Meenakshi Lekhi of Bharatiya Janata Party, and this bill actually is passed after the recommendations of Justice B.N. Sri Krishna Committee that was set up in year 2017 to look into the matters of personal data. However, the bill has been diluted, and the modified version of bill has been opposed by Justice B.N. Sri Krishna, and he has said that the modified version of bill actually threatens the democracy of India, as government has given itself a very we can say government has given itself a power where it can access any personal information that is available on the internet or any such information that is available to the government agencies if it feels that there is a threat to the sovereignty and public order of the country. However, he believes that such kind of steps or such kind of bill or act, if passed, can threaten the democracy of India and also can make India an Orwellian state. Now, if you look at what is the Personal Data Protection Bill, so basically it issues or addresses two issues. First of all, it clearly explains that what is the mechanism that should be put in place for India for protection of personal data of all its citizens. At the same time, it also discusses about setting up an authority that is called as Data Protection Authority of India to look into the matters of breach of private data as well as to look into the matters that is arising out of the breach of the private data. Now, if we try to compare the India's situation with the global scenarios, and what is the stances of different countries across the globe regarding the right to be forgotten. So, three major examples we can look. First of all is the example of whole European Union, where European Union has established a rule that is called as General Data Protection Rule, or GDPR in the short. Under this GDPR rule that is established by the European Union, under Article 17 of this GDPR, they have clearly said that every person has a right to erasure of certain categories of personal data. Now, what is this certain categories of personal data? So, this is explained by European Union, as this data is something can be that is of no use to the general public. Data can be such data which has been we can say appropriated illegally, or certain data that as per judicial intervention or as per this understanding of judiciary threatens the security of that particular person, or also that particular data that actually does not serve any public functions as such, and that is why it should be erased if the person wants so. However, certain exceptions are there that has been made in this particular Article 17, that data cannot be erased if it is serving any public interest, or if it can be used for any scientific or historical research or any statistical purposes, and in accordance and for establishment, exercise or defense of legal claims. If any of these criteria are met, then the private data can be believed to be of public use and should not and cannot be erased from the public domain. Now, we look at that what is the stance of United States of America the oldest democracy of the world. So, two cases are there. The first case that was referred to the judiciary was a case that is called as Melvin versus Wright in year 1931. Here Supreme Court has clearly said that every person has a right to be forgotten, and if demand, like actually what happened, this case was for a particular woman who was acquitted, who was accused of murder. However, later on she was acquitted, and that is why the data is still, or the information still was there in the public domain that she has been accused of murder, and that is why she wanted to have a fresh start, and she approached the Supreme Court and asked all the information to be removed from the media. In 1931, we did not have any internet, so that time it was all the media, newspaper, and all these journals were there. So from there, she wanted, also a movie was made on her, so she wanted such movie to be censored and all these kind of things, and Supreme Court uphold his point of view. However, we see a change of stance in the judiciary of judiciary of United States of America, when a matter that is Sidis versus FR Publishing Corp was referred to it. Sidis was actually a child prodigy, and he wanted to live a very calm life away from all these media houses and away from the glare of media and all these things. Again, another movie was made regarding Sidis, and Sidis did not liked it, and he approached the Supreme Court and asked that movie to be censored and all the information regarding him being a child prodigy to be removed. However, Supreme Court took a second stance or different stance this time and said that just because a person is celebrity and he do not want to be referred as celebrity and do not want to feel like a celebrity does not mean that the data or the information regarding him should be erased from the internet or any kind of media. And Supreme Court said that no such censor can be put on the film or put on the movies, as it directly confronts or directly affect the right to freedom of speech and freedom of expression. So here the Supreme Court of USA has said that right to be forgotten directly we can say confronts with the right to freedom of speech and right to freedom of expression, and on this ground this right should not be exercised. So right now that is the whole issue in the USA, where the right to freedom of expression is believed to be under the First Amendment of this Constitution is believed to be the most outstanding right and should not be curtailed on any other ground. Now if you look at what is the stand of Russia on this particular matter? So in year 2015 actually, Russia allowed any user or any of its citizen to force a search engine to remove any links that is referring to his or her personal information on grounds of either irrelevancy, inaccuracy, or if it is a violation of law. So that is some of the global scenarios that we discussed regarding the right to be forgotten. Now coming to the issues, that what are the issues surrounding this particular issue, this particular right. So first of all, as we discussed and as the matter is continuously coming in the USA, that right to be forgotten directly confronts with the right to freedom of speech and as well as right to know about certain things for the general public. Second issue is regarding that it is believed that if every person is given the right where he want to be forgotten, where he want all his personal data information to be erased from the public platform or erased from the internet and search engines, then it will be amount to a censoring effect on the search engines as well as internet, and it will have a serious chilling effect on the freedom of speech, expression, as well as the freedom of media. The third point is regarding that it is believed that if Google is continuously getting the request of erasing of multiple data coming from different individuals as well as different agencies, it will actually affect the integrity of internet based information, as by erasing such data, Google or any such search agencies may be providing a biased information. If suppose that two viewpoint is there regarding to a particular matter and two persons are there that are involved, and one person asked Google that he exercise his right to be forgotten and want all the data and all the information about his viewpoint to be his viewpoint to be erased, then now we will have only one viewpoint about that particular matter, and that will affect the integrity of internet based information and the reliability of such platforms for the users. So this is the whole three major issues regarding right to be forgotten and all the other issues regarding that. Now coming to that, what is the way forward or what is the way out? So a CISPA, that is an agency of USA, a Sarland University and the University of Auckland together has developed a platform that they called as Oblivion. And Oblivion will actually support the automation of the right to be forgotten in the future if it is exercised, and if it is such laws or statutes are passed by the legislative and exercised by the person or individual, then it will automate the right to be forgotten in a scalable, provable and a privacy preserving manner. That means now obviously, if right now if we talk about what is happening right now, if suppose a person wants to exercise his right to be forgotten, then he has to write a message to the Google or send an email or in some way approach the Google and ask that particular section of information regarding him has to be erased. Now the Google will refer this matter to a particular person, and this particular person will look at all the matter, and then he will do this all these things manually. Erasal of data will happen manually. So that is why later on for future this platform will help a lot by supporting the automation of that particular information, supporting that particular act, and it can be scaled up and it can be proved efficient, and also it will erase the data in such a way that privacy of that particular person is respected and preserved. So this is something that can happen in the future if everywhere across the world the government agencies give the citizens right to exercise his or her right to be forgotten. However, still it is a developing issue. The right to be forgotten is still, as the Government of India has stated, is in a stage of evolution, and unless and until it becomes or takes a concrete shape or concrete form, we have to understand that no certain guidelines, or we can say that no certain guidelines can be given by the government in this regard. So we have to look at also at the Joint Parliamentary Committee as far as the India is concerned, that what is their decision and how they what are the stand they are taking on this particular right, and also we have to look at that what is the judicial or judicial understanding about that particular issues. So as of now, this is all about this particular issue. I hope you understand this topic. If you like this video, please like, share and subscribe. We'll come very soon with another interesting and current affairs topic. Till then, take care. Thank you very much.